The U.S. Territorial Sea and other lines in the water. The modern concept of the Territorial Sea owes its genesis to Hugo Grotius and his work Mare Liberum, Freedom of the Seas in 1605. He argued, among other things, that a coastal nation couldn't claim sovereignty over the seas beyond the range of its control from shore. This concept developed over time into the cannon shot rule and eventually the 3-mile rule, the first holding that the coastal nation's sovereignty couldn't extend further than the distance from shore that it could fire a cannon, the second that, for sake of uniformity, the sovereignty of all coastal nations should not exceed 3 nautical miles offshore. While the majority of coastal nations followed the 3-mile rule for many years, acceptance wasn't universal. Following some initial opposition to the position espoused by Grotius, Britain eventually became the prime supporter of the concept of the freedom of the seas and the concomitant view that the territorial sea for coastal nations should be limited to 3 nautical miles. This maritime legacy was carried to the American colonies and adopted by the new government of the United States of America following independence. While no specific statement addresses the extent of the basic U.S. territorial sea, various regulations reflect the traditional position that the extent of such claim is 3 nautical miles from the baseline, which is generally the low water mark. In simpler times, the United States had only one territorial sea, which was all things to all people. The nation had, with reasonable consistency, claimed a territorial sea 3 nautical miles in breadth since its founding in 1798. Within the territorial sea, being under the full sovereignty of the United States, all U.S. laws are enforced, as well as those of the adjacent coastal state of the United States. Over time, various needs arose which could only be efficiently dealt with by selectively asserting federal jurisdiction beyond 3 miles offshore. A contiguous zone out to 12 nautical miles allowed for the enforcement of custom, sanitation, fiscal, and immigration laws. In 1945, with offshore oil and gas drilling become more productive, President Truman asserted jurisdiction over the economic resources of the continental shelf of the U.S. coast. With the increasing efficiency of fishing technique, depletion of the living resources of the sea became an issue. The U.S., not unlike other nations, tried a combination of limited unilateral control and multilateral cooperation, but to little effect. Eventually, the U.S. joined the increasing number of nations claiming an exclusive fisheries zone, now called an exclusive economic zone, extending 200 miles offshore. Federal water pollution laws were also extended to cover the same area. None of this claim, though, attempted to assert U.S. sovereignty beyond the traditional 3 nautical miles, even though an increasing number of nations were claiming territorial seas of 4, 6, 12, and 200 miles. This changed in 1988 when President Reagan, in response to the increasing threat posed by Soviet spy ships hovering off the U.S. coast, proclaimed a 12 nautical mile territorial sea. The proclamation specifically limited its application to international law. The proclamation specifically left undisturbed the 3 nautical mile territorial sea for all domestic purposes, including law enforcement. Thus, the proclamation only real effect was to require the spy ship to move further offshore. The proclamation did, though, cause a re-examination of the domestic concept of the territorial sea, resulting in a willingness to deviate from the traditional 3-mile rule if need be shown. The situation has become immensely more confused with the passage of the Anti-Terrorism and Effective Death Penalty Act of 1996. Section 901 of this statute declares that all of the U.S. territorial sea, as defined in the 1988 Presidential Proclamation, is for criminal law purposes, part of the United States subject to its sovereignty and is within the special maritime and territorial jurisdiction of the United States for purposes of Title 18 U.S. Code, the Federal Criminal Code. The section also amended the Federal Assimilative Crime Act to include within its ambit the newly expanded Territorial Sea, while making clear that this expanded area wasn't within the jurisdiction of the adjacent coastal state. The legislative history of this section is sparse and the goal of Congress in this regard is unclear. While the previous confusion regarding the breadth of the U.S. territorial sea was real, it was also largely academic. Now, there are potentially serious consequences involved and little guidance is available to the mariner navigating in the zone between 3 and 12 nautical miles off the U.S. coast. Certainly, all the prior laws still apply in these waters. This issue is which additional laws apply within this 9-mile wide zone. First, all criminal laws appearing in Title 18 of the U.S. Code seem to have expanded their coverage. Second, criminal laws, the coverage of which is defined by the special maritime and territorial jurisdiction, have also gained expanded coverage. Most, but not all, of this latter group are found in Title 18, so the actual number of additional laws the coverage of which is expanded by this provision is minimal. A more problematic matter is whether all other federal criminal laws have gained this expanded coverage. The language is loose and the legislative history is silent. The effect of the expansion of the Federal Assimilative Crime Act is, as yet, unmeasured. This stated absorb or assimilate into federal law the state criminal laws of the adjacent state in matters where the Federal Criminal Code is silent. The issue of whether an act is covered by an existing federal criminal statute, thereby prohibiting the use of the Federal Assimilative Crime Act, tend to be narrowly construed so as to allow for the incorporation of state criminal law in any case where the federal law isn't exactly applicable. Originally designed to address military installation and Indian reservation, its effect in this newly expanded territorial sea may be the most significant legacy of this unheralded section of the new law to deter terrorism. Section 702 of the Anti-Terrorism and Effective Death Penalty Act of 1996 addressed acts of terrorism transcending national boundaries. While making terrorism involving foreign commerce a separate crime denominated the federal crime of terrorism, the measure defined the U.S. territorial sea for purposes of that section as all waters extending seaward to 12 nautical miles from the baseline of the United States determined in accordance with international law.